So good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, March 11. As you can see, Justice Gonzalez is virtual. She's appearing on the screen. Please ask for the time that you actually need in order to get out the salient points of your arguments. Please understand that we have read your briefs and we are fully familiar with those arguments. Also, please note that the red light is for you, not for us, so that if we do in fact have additional questions of you, we will certainly pose them. People v. Renee Garcia. That matter is submitted. Burstein versus Watson. Please stand. I'm sorry. Also, when the case is called, please stand and state who you're representing.
For the appellant, part attachment by Ronnie Shadell, requests 8 minutes on argument, 2 on rebuttal.
Five and 2 and 5. Matter of Kamel. That matter is submitted. Shuan v. Rivera. How much time are you requesting? And any time on rebuttal? 3 minutes. Mr. Rivera? Certainly. 5 and 2 and 5. Abu Hamadia versus NY Presbyterian, New York Presbyterian Hospital. So you are the appellant. How much time are you requesting?
Yes, Your Honor. I request 15 minutes argument and 3 minutes rebuttal.
And New York Presbyterian?
Morning, Your Honor. Justin Guilfoyle, Baker Hostetler, requesting 5 minutes.
5, 2, and 5. Fidelity National versus Sky Abstract. Appellant? Respondent? Sky is not present. Okay, 5 and 2 and 5. Narez v. 12 West 31st Street. The respondent's here. It's just a little slow to rise. How much time are you requesting? Respondent? 5, 2, and 5. People v. Jose de Leon. That matter is submitted. Canalis v. Noble Construction. You represent? Okay, who's the appellant? Canalis?
No.
Yeah, so could I have the appellants first, please? Your appellant, first appellant, Noble, and you're requesting? You represent? Five, 2, 5, 2, 5, 2, 3. Thank you. Almadova, versus the City of New York.
Plaintiff appellant, 5 and 2.
5, 2, 5. Matter of Messiah. Matter is submitted. People v. Charles Cherry. Matter is submitted. Gonzalez v. 60-74 Gansevoort.
Defendants, appellant,
5, 2, 3. KSFB Management versus Focus Financial. I'm sorry, who do you represent? 626. Wesco Insurance versus Nunez Dental. That matter is submitted. People v. Omar Key. 5, 2, and 5. Homelink International. Matter is submitted. First case for argument is Burstein versus Watson. Whenever you're ready, Counselor.
Good afternoon. May it please the court, for the defendant appellant Candace Watson, prior cashman by Ronnie Schindel. This matter should actually be quite simple, and it really boils down to, with respect to the issue of the petition that was ruled by the lower court to have essentially not existed, that there is the irrefutable fact that it did. However, the court did not focus on the proper evidence when it made its ruling. And in fact,
What ruling are you referring to, Counselor?
I'm talking about Judge Chesler's December 21, 2022 order, where he said, regarding the cross motion, the court finds no basis to dismiss or consolidate this action.
Well, what action, okay, so what action would be consolidated? What was the other action to consolidate this action with?
There was a petition filed for support by my client in January.
Where was that petition filed?
It was filed in Supreme Court, the very court that, upon which it was ruled that it wasn't there, but in front of a prior judge, Judge Cooper. Okay, and the fact is that when Judge Cooper was replaced by Judge Chesler, he was advised that there hadn't been a proper petition filed, but in fact it was. And what happened was there was a back and forth on the record about an order to show cause that was signed by Judge Cooper. But what was shown in the underlying motion in the lower court was that the order to show cause that the lower court relied upon was in fact not the one that was actually ultimately signed. There were two of them.
The petition for child support where was that filed?
Supreme Court, New York County.
And can you file a petition for child support in Supreme Court, New York County?
Yes, you can. And in fact, we're here on a proceeding that involves the petition that was filed ultimately by the respondent here, which was filed to supplant the prior petition that was filed a year and a half earlier. But what happened was the lower court relied upon what was scribbling essentially on an order to show cause, which I call in my papers the stale order to show cause, which was signed on May 3rd, 2021. The actual order to show cause ultimately signed by Judge
So the
Cooper was May
initial
4th.
petition for child support was filed in Supreme Court.
Yes.
Supreme Court specifically stated that it did not have jurisdiction to hear that issue because support is within the exclusive jurisdiction of family court, and it should not have been filed in Supreme Court. Supreme Court stated that it would review other issues, but it specifically stated that it was not going to deal with the issue of child support.
That was Judge Chesler quoting Judge Cooper, but it was based upon the stale order to show cause, because ultimately Judge Chesler accepted the follow-up petition for child support that was filed by respondent below, which is the live action, which is the index that you have here.
Didn't Judge Cooper say that he was not going to consider child support, but that he was going to do an interim financial arrangements for this couple?
That's what the other side says, but that's not what happened. Ultimately, what happened was there's the May 4th order to show cause, and if you look at the record, okay, page 407, okay, and then 449, that's the actual corrected order to show cause. You'll see the correspondence between counsel where they explain that there was a mistake.
So May 3, 2021, Justice Cooper states that he asked the parties for their positions. The father attempted to bring up financial issues. The court explained, I'm making my determination as to assets. It will have nothing to do with finances. That's something that should be done in family court, which has a whole world that is established for determining child support for unmarried people.
He ultimately changed his mind. That was on the record. That was on May 3rd. what I asked the court to do is to look at the order that the judge ultimately
So what did I?
on May 4th.
I mean, I thought he was doing this as an accommodation because at that particular time, while Judge Cooper was still sitting on the bench, it was still, we were coming out of COVID and family court was really, really backed up. So I thought he was doing this as an accommodation. What did he say he was going to do about child support? Didn't he tell you to file it in family court, go there, and he would just move along with other issues in the case?
At one point, he said it. Ultimately, he changed his mind because he signed the May 4th order after correspondence.
Which said
with his-
what?
Which said that it was going to be heard before him. And in fact, ultimately, it was heard before that court and is still being heard before this court. But the question is whether the original petition still survives, which it should, which at this point is 5 years of retroactive child support. There is nothing in the record to support the fact that that petition was ever dismissed. No order of dismissal, okay? And the order that was ultimately signed by Judge Cooper, okay, order to show cause, May 4th, 2021, says that the claim survives. And you could see the prior one that was a mistake on May 3rd, okay, was supplanted by the May 4th one. It's all on the record, and you can see the correspondence with the court where my prior counsel, Julia Maxfield, said that this was a mistake, okay, you sent me the wrong one, and then it was replaced by May 4th. The other side argued that it never happened, but there's no
Counsel,
mention
if
of
I
it in the
may,
case.
counsel, I know that you're also challenging the court's denial of sanctions. And my question to you is, how did the father's counsel engage in frivolous conduct by filing that petition that was done in response to the court's instructions and as well as the parties' agreement?
The reason why is because the obstructions were obtained from the court based upon misleading the court as to what had actually happened. Ms. Rabin, who was prior counsel, not present here, did not advise the court of the exchange that I've been explaining about this morning, which is all supported in the record. She was CC'd on those emails. She knew of it. And in fact, it was compounded when I had to file the motion to consolidate, to preserve that prior petition that was never dismissed. She didn't even respond to the fact that I revealed these emails that she was on. She pretended they didn't exist. And in fact, the brief now that's been filed by respondent here doesn't deal with it because they know the truth. It's incontrovertible. It's very clear that that exchange happened, and they're relying upon the order to show cause, and they forced Judge Chesler to rely upon the order to show cause that was ultimately replaced by another one a day later. It's all on the record.
But counsel, the order you're talking about that was replaced a day later, in that particular order, I thought that your client stated that she was withdrawing her petition for child support.
No, the only thing that was withdrawn was the request for the order of protection. That was stated
Well,
at a
the
higher
court
idea.
signed the mother's order to show cause, indicating that her request for an order of protection and for child support had been withdrawn during court proceedings.
That was the mistake. That's the May 3rd. You have to look at the May 4th order to show cause, okay, which is the corrected one, which is at page 449 of the record. It also includes the email of the court and the email change showing the back and forth where the mistake was revealed and the court changed it.
But again, did not the judge specifically state that he was not addressing the issue as to child support?
Earlier, but not later. The last word of the court was in the corrected order to show cause of May 4, 2021, which is located at 449 of the record. The judge signed that, and the fact that he corrected the prior one.
Well, what he signed was, again, stating that she was withdrawing her petition for an order of protection, not that he was going to entertain the petition for child support.
He did, yeah, the one on May 4th, he did. It does indicate on the bottom that if you look at the May 4th order versus the May 3rd order to show cause, you could see the May 3rd has the child support request crossed out, and the May 4th request for child support has.
Right, but that was
reinstated.
based upon his misunderstanding that she was withdrawing that claim, not that he was going to entertain that claim.
It was that he was going to entertain it, because the fact is that if you look at the letter of Ms. Maxfield to the court, where she says, Your Honor, you sent me this May 3rd order to show cause, and it's mistaken, it crosses out child support, we're not withdrawing it.
Right.
However, if the court rules that, we understand, but the court then changed it and then issued the May 4th order to show cause, and then in fact issued a child support order, which is the order that's issued on the modification, which talked about ensuing discovery, preserving rights at trial, and so on. If in fact he wasn't entertaining it, Judge Cooper, very fine
said
judge,
he
he would
was
have
gonna-
issued an order of dismissal. He never did that.
He said he was going to entertain it to the extent of, he wasn't entertaining it, but that he was going to order discovery and other and documentation regarding it, but that he wasn't going to make a determination.
Yeah, because in his order, it does say that, because in the order, he talks about the trial. Yeah, he talks about having a trial on it. So there's nothing, other than the colloquies on May 3rd, which preceded the ultimate order of the court issued in the order to show cause on May 4th, there's nothing to support the fact that Judge Cooper wasn't going to entertain it. That was earlier discussion, but ultimately he decided to keep it as evidenced by the May 4th order to show cause. If he wasn't going to keep it, he wouldn't have changed the order to show cause. That's the only difference between May 4th and May 3rd.
We don't know.
Well,
Anyhow.
you're correct.
Again,
We can't
you
know
can
what's in
read
his
it-
head, but his
you
acts.
can- You read the order, you read what was stated, and then you read the record in terms of what he stated. But you have time on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court. My name is Jennifer Montoya of Kraus, Shackney's, Talentire, and Messeri on behalf of the respondent father, David Burstein. Clearly, there's a convoluted procedural history that took place in this matter. Neither Mr. Schindel nor myself were present at the May 3rd conference, wherein Judge Cooper repeatedly stated on the record he was unwilling to address the financial aspect of this case as it was in the wrong forum. And if the parties were to resolve child support, they needed to do so directly or by a new application submitted to the family.
Is counsel not correct that something different happened the next day, that Judge Cooper signed an order to show cause that said something different than what he said on the record on May 3rd?
He did sign the order to show cause on May 4th and then subsequently issued the May 21st, 2021 order, which delineated interim basic child support and add-on expense provisions that was agreed upon after extensive dialogue between the parties and Judge Cooper on the record, where he repeatedly stated again, I will not be making a determination regarding child support or finances. And then he pressed the parties to discuss the extensive dialogue that they entered into with their mediator for months prior to returning to court before him. And he asked them, he had said, I am here to deal with custody. Now that I'm issuing an interim access schedule 8-6 in favor of the appellant mother, again, I'm not dealing with finances, but the non-custodial parent, meaning the father, does have to support his children.
So the issue is that May 21, 2021 order, that interim order that Judge Cooper issued, memorialized the May 3rd court proceedings.
Which my understanding was entered into on consent of the parties.
Yes, but your friend is stating that there was something different that occurred on May 4th, wherein Judge Cooper apparently represented that he was in fact going to address the support issues.
I have a different understanding of what happened at that conference, where the judge ultimately said, even though I am issuing this interim order, I want to make it abundantly clear that I will not be issuing a final determination regarding child support, and again reiterated that the parties either needed to resolve that issue directly or start a new action in family court, which is the appropriate forum for unmarried litigants.
Would it make a difference whether Judge Chesler was looking at the May 3rd order to show cause where child support was crossed off, or the May 4th order to show cause where child support was included?
I think the disputed order on its face speaks for itself, where Judge Chesler made it very clear that he looked at the totality of the facts presented, which included the written brief submitted by the parties, the on the record directives and orders issued by the court, and after having several conferences with the parties and counsel to assess the validity of their respective claims, he came to the conclusion that Judge Cooper was not willing to address the financial aspect of this case. However, the equities of the matter, based on the stated preferences of the parties to streamline this case instead of bifurcating finances from custody in a different forum would allow Judge Chesler the ability to hear the financial aspect of the case, but there was unified confusion between the parties and counsel, including the appellant and Mr. Schindel and the court, as to the appropriate mechanism to bring a new child support application before the lower court. Accordingly, Judge Chesler instructed the parties that they were to determine an appropriate mechanism, meaning a new application to be presented before this court so that he could hear child support. Shortly thereafter, the respondent and his prior counsel, Ms. Rabin, filed the subsequent action, which was based on the prior directives of the lower court and which the appellant and Mr. Schindel agreed was the appropriate course of action, and thereafter they changed course and now seek to admonish the respondent and his prior counsel for following the directive of the lower court.
So where was that action filed? That second action was filed in family court or in Supreme Court?
It was filed in Supreme Court at Judge Chesler's instruction during the June 2022 conference, wherein all parties and counsel, including Mr. Schindel, expressed agreement that this was the appropriate course of action. In any event, the best remedy to address any perceived grievances with a pendente lite order is a speedy trial, which has yet to happen and which is available to the appellant. Thank you.
Thank you.
There's nothing in the record post-May 3 to support what was said to this court about what.
Well, yeah, we have a May 21 order where it memorializes the May 3 order.
Yeah,
No,
but it
excuse me,
doesn't
the May
talk-
3 the May 3 proceedings.
But it says nothing about going to family court. It says nothing about the court.
Well, it says I'm
maintaining
not going to
jurisdiction.
deal with the support issue.
The May 22 order doesn't say that.
May 21, that's what, I thought that's what, if
No,
it
no, no, that's being what-
memorializes,
that-
if it memorializes the May 3 court proceeding, then it states that what Judge Cooper stated was that he was not going to deal with support.
That's not in that order. That was stated on the record on May 3rd, okay? What was in the order ultimately that was issued was nothing to the effect that the court was not going to maintain jurisdiction over the original support petition that was before it at that time, okay? And these alleged discussions and so on, they're not on the record, they're not in the appellate record. All this court has.
Counsel, if I may, I'm on the screen.
Oh, I'm sorry, Justice Gonzalez.
It's okay, it's okay. I'm looking at the May 21st order, and the child support portion of the order is called interim child support payments. And at the interim child support I'm referring to record page 16. The interim child support payment and add-on provisions are made without prejudice. Neither party shall be precluded from seeking a modification of interim child support upon financial disclosure from the other, and each party's right to seek discovery and or a contrary award at trial is preserved. So to the extent that there is a controversy here between the parties as to what Judge Cooper meant, the document says interim. The Supreme Court assumed jurisdiction of a dispute between non-married parties. What is to say that Supreme Court is required to decide child support?
Well,
I don't see it.
Sure,
I mean,
Your
where
Honor.
is it borne out in the record, Counselor? Fortunately, since I have the computer right here, I can look at everything while you all are talking.
Sure, Your Honor, I'll respond to the question. There's always an interim order, whether you go to family court or Supreme Court, in almost every case, that's a pendente lide order. And you always have a right to change it at trial. And in fact, this is the point I was making earlier, that it spoke about ensuing proceedings for discovery and ensuing proceedings for trial.
My
Not that it was
question,
not that it was
Counsel,
being dismissed, so the fact,
Counsel, that's not my question.
okay.
What I'm saying to you is, to the extent that Supreme Court assumed jurisdiction of a dispute between non-married parties during the epidemic, at a time when family court was overburdened, grossly overburdened, why is Supreme Court required to now determine child support, understanding that family court has sole jurisdiction, exclusive jurisdiction?
My understanding is that they do not have exclusive jurisdiction. Supreme Court can assume it when they do, and there are cases where it happens. And in fact, it's happening now, just under the dad's petition, which is still live. So really, what this is about is whether you're going to dismiss a petition that's never been dismissed, and that there's nothing in the record to support it being dismissed, other than a colloquy that happened on May 3rd that was followed by an order of the judge that was involved in that colloquy, where he changed an order to show cause that had previously crossed it out and then put it back in. So to me, the question is,
But counsel, Justice Weber made a reference to Justice Cooper's very adamant statement at record 91, where he said that he was not going to make a decision as to finances. It would be determined in family court. He never took that back.
he did take
never
it back.
changed
Oh,
that.
sorry. He took it
Go
back
ahead.
on May 4th when he signed an order to show cause that corrected an order to show cause that was issued the day before the day of the colloquy. And I mean, look, I think there's a lot of speculation going on. Obviously, there were things that happened off the record, and that's what Ms. Maxfield referred to in her email correspondence to the court, where she said that you sent me an order to show cause that took away a child support claim that was never withdrawn. If the court would like to withdraw it, I understand. But then the court followed that up the following day with an order to show cause that reinstated the child support claim. So that's what we have.
The order was incorrect because it stated that the parties had withdrawn, that your client had stated that she was withdrawing both claims for the order of protection as well as for support, and that was incorrect. So he's correcting the order.
Correct. And then he issued a support order, and in the support order said nothing about dismissing the petition, nothing about transferring the petition, and talked about proceedings in that court before that judge involving discovery and a trial. So to me, I think that if the petition of my client is going to be considered as a non-event, there needs to have been something in the procedural record to support that. In fact, there's not. And to me, the fact that in the respondent's brief and in the underlying motion papers, the fact that neither counsel commented at all about what happened with that May 4th order to show cause is quite telling, because the fact is that the discussion that was referred to by respondent with Judge Chesler was predicated upon Judge Chesler seeing the May 3rd order to show cause. I wasn't there for the May 4th order to show cause. I found out from prior counsel, yet Ms. Rabin was there, didn't mention it, and when I brought it up in the motion papers, she didn't respond to it, because everyone knows who was there, that that's what happened, that it was never dismissed. So to me, I asked the court to just go by what was actually done by Judge Cooper, okay, and to follow the
Thank you,
record
counsel.
in sequence.
We will do so. Thank you so much.
Thank you, Your Honor.
Shuan LLC v. Randy Rivera. Yes.
Good afternoon, Your Honors. May it please the court. My name is GQ of the Hand Associates, appearing on behalf of the appellant Shuan LLC. This appeal asks whether a rigid one-sentence dismissal based on a mathematical calculation of time should override the state's strong public policy of resolving cases on the merits, especially when the delay for the appellant to submitting judgment to the clerk was directly caused by an unprecedented global pandemic, and their defendants suffered no prejudice from it. In our brief, we articulated that the appellant has.
What was the law office failure?
It was It was July 11, 2020.
The associate responsible had apparently left the firm.
Yes, Your Honor.
So was this a law firm that only had one associate?
No, Your Honor, but
So why could another associate or someone else from the law firm proceed with the litigation?
Your Honor, the case was not timely reassigned to a new associate because shortly after the associate left the firm was had to basically shut down due to COVID restrictions.
Well,
At
I thought that the associate left the firm during the summer in July of 2019, and we know the pandemic didn't start, or maybe in October of 2019, but again, we know the pandemic didn't start till March of 2020. So all those months, nobody looked at this case?
Your Honor, that's partially correct, but one important factor is that the principal of the appellant, Karen Tan, she was stranded in China during that period until.
Yeah, I know you say that. How are you stranded? I mean, what did you mean by stranded? During that period of time, there still was communication possible between the United States and Japan.
Your Honor,
China, excuse me, in China.
Yes,
So I don't understand what you mean by stranded. She was totally incommunicado?
Your Honor, we will not be able, the law office was not able to communicate with.
Why?
Karen Tan. I have no personal knowledge about the reason, but during that period, there's no communication.
So from my recollection during that period, as I stated, there was still communication possible between the United States and China. So you don't state in your papers what it was, if anything, which prevented you from communicating with her.
Yeah, Your Honor, the reality is that the client never established contact between this office during that period until her ultimate return to the United States in February 2023. And upon her return and the communication, we promptly resumed a discussion and prosecution of this
Couldn't have
case.
Zoomed while she was in China?
We will not be able to, due to the lack of communication, we do not know her intentions as respect.
Well, isn't that something that you should know for purposes of this litigation, where you're claiming that there was some issue in terms of communicating with her? Shouldn't it be clear as to why you were unable to communicate with her?
Your Honor, unfortunately, due to the.
You don't explain how or why there was any disruption in the communication with her.
Your Honor, it simply did not happen. I do not know the reason why, due to the departure of the former associate. I mean, that's all I can say, represent to this court.
Counsel, the
Counsel.
default judgment was entered in July of 2019, and the assigned associate departed October. Was there any explanation on why there was no activity, no attempt to, seek the entry of a default judgment, in the 3 months?
Your Honor, one reason that we did not seek immediate entry of default judgment is because we had communications with the defendant. I believe back in July 2019, we emailed the defendant, and the discussion was, I quote, the defendant just filed a show of cause for the stay on the pending default judgment, and, quote, continue our conversation about settlement. We rely on this representation.
So you relied on this for 5 years?
Not 5 years, Your Honor.
Well, that communication was on July 16, 2019. You did not seek entry of the default judgment until July 2024.
That's, Your Honor, that timeline skips the intervening events. The office was reopened on March 22nd, 2019, shortly after the 1 year time limit expired. I mean, it's just unfortunate sequencing of events.
You have
Justice
time.
Weber, may
I'm
I
sorry,
ask
go
one
ahead.
question? I know that the firm resumed operations in July 2020. Was there any explanation provided as to what prevented the firm from seeking entry of the default judgment once the firm resumed operations?
Your Honor, I know not the exact reason. It's simply we were trying to catch up on all the disruption of the cases prosecutions, and we discovered this default only upon the client's return and the internal audit.
Thank you.
Thank you, Your Honor.
Yes, Mr. Rivera.
Good afternoon, Your Honor. It took them 4 years, and the email that the counsel is mentioning that I responded, that was
Was there any communication between you and the plaintiff between July 2019 and July 2024?
no.
So you had a communication with them in July 2019 wherein you stated that you would, that you would continue, you were working out, or there was some eye towards some type of a settlement?
Not really. I mean, the original counsel actually even told me that I know there's no merit to this, but as long as their client is paying us, Mr. Rivera, we have to keep talking to you. And they know exactly what where the fraud came, and the appellant is just like scapegoating me for the business that she was trying to run. And I said that I don't understand what's happening, and then I never heard from the lawyer, and then they changed 3 more times after that. So because I'm representing myself, so I'm just trying to communicate with them and see where they're at. But I never talked about like settlement. I never admitted. They also tried to depose me. And so they said, can you come to the office? And so they're just trying to do a show towards their client that there's something in there.
Did they ever depose you?
Yes, the second out of the 5 lawyers did ask me to go, because, you know.
You know
I'm
what
just-
year that was? When was?
What year?
What year that was?
I don't remember, Your Honor. I don't remember. But like I said, I have the text,
It's okay.
maybe the emails.
Thank you. Any other questions? Oh, thank you so much.
Thank you.
May it please the court. I want to respond to respondents' comments during the argument. First of all, respondent was deposed in 2018, and the underlying cause of action is breach of contract.
2018?
Yes, Your Honor. 2018, yeah, the respondent was deposed, and the underlying cause of action breach of contract. Basically, my client, Shuan, hired respondent as a consultant to place students for internship with certain financial institutions. And there's no dispute during the deposition that respondent admitted he signed the consulting agreement, and he took in $40,000 of consideration. And he even admitted during deposition that he failed to place even 1 intern. So the appellants respectively submit that we have meritorious claims of action. Thank you, Your Honor.
Thank you. Hambia versus New York Presbyterian.
Good afternoon, Your Honor.
Just wait for your friend to
Oh, sorry.
get settled. You're quite welcome. Okay, thank you.
Good afternoon, Your Honor. My name is Hisham Abu Hamdia. I'm a plaintiff appellant appearing pro se. I am here today because the Supreme Court made a fundamental error of law. The lower court dismissed my entire complaint under the election of remedies doctrine found in exclusive law number 2979. The trial court ruled that because I filed a disability discrimination claim with the Division of Human Rights, I was barred from bringing this lawsuit. But that ruling conflates 2 entirely different areas of law. My complaint in this court is an independent whistleblower retaliation claim under New York labor laws number 740. It is based on the fact that I was fired for reporting my employer's New York Presbyterian Hospital wage theft, misclassification of the job I work, worker compensation of fraud to the U.S. Department of Labor and the Worker Compensation Board. I ask this court to reverse the trial court dismissal based on two main points, Your Honor. The first point is, as a matter of law, the election of remedies doctrine under human rights law does not bar a separate and distinct statutory claim under labor law number 740. They have different factual predicates, protect different activities, and offer different remedies. The second point, Your Honor, as a matter of procedure, the trial court failed to apply the correct standard of review under CPLR 3211 by stating that my whistleblower claim was belied by review of the complaint, record page 4, Your Honor. The court completely ignored my detailed preliminary statement, record pages 7 to 10, Your Honor, and the generous pleading standards afford to pro se litigants. So I'm going to go over the points. Moving to my first point, Your Honor, the trial court fundamentally erred by applying the election of remedies doctrine to a labor law section 740 claim. Your Honor, exclusive law section 2979 is narrowly tailored by its own text. It only prevents a plaintiff from pursuing relief in judicial form for the same New York State human rights law claims that are already pending before the Division of Human Rights. The trial court relied on this court precedent in Magini versus Otnor Ltd. Number 180 AD 2D476. But Magini, Your Honor, is distinguishable and does not apply here. Magini, Your Honor, involved a plaintiff trying to duplicate her exact same discrimination claim in both the agency and the court. That is not what I'm doing here, Your Honor. My NYS Department of Human Rights complaint found at record page 67 is strictly a disability discrimination and accommodation claim under the human rights law. In stark contrast, my Supreme Court complaint brings an independent standalone cause of action under New York labor law section 740, the whistleblower protection statute. As this court has recognized in case like Lee versus ABK Bank, 131 AD 3D273, and also Demer vs. Sanchez Inc., 155 AD 3D464. It claims that seek different rights and remedies under separate statutory schemes are not barred by the election of remedies doctrine.
So you have time on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. Justin Guilfoyle of Baker Hostetler on behalf of defendant respondent, the New York and Presbyterian Hospital.
So would you address his arguments in terms of the election of remedies doctrine?
Sure, Your Honor. The lower court properly held that the election of remedies doctrine applied here because on the face of the complaint, the allegations confirm that appellant is in fact asserting disability discrimination and disability retaliation claims under the human rights law. There's several paragraphs within the complaint that confirm this. For example, paragraph 21, my termination was in close proximity, less than 2 months to my request for an accommodation, and as such, I was terminated in retaliation. Paragraph 34, rather than engage in the interactive process, provide a reasonable accommodation, or provide a reasonable alternative, I was subject to retaliation. And then the complaint closes with respondent thereby violated Article 15 of the New York State Executive Law and caused me damages. That's reference to the New York State Human Rights Law. And the concluding paragraph states that I also charge that the respondent has violated the New York State Human Rights Law, Executive Law Section 296, on the basis of my disability and retaliation.
But he's also claiming.
So, counsel,
I'm sorry, go ahead, Gonzalez.
thank you. The appellant argues that there's a distinction between filing a discrimination claim and filing an action based on whistleblower retaliation. Are they one and the same thing, or are they separate?
So in theory, they are separate things, Your Honor. There are distinct causes of action for New York Labor Law 740 whistleblower claims, and there's distinct causes of action for discrimination and retaliation under the New York State Human Rights Law. However, the face of the complaint and the thorough reading of the complaint confirms that there are no whistleblower allegations or a prima facie case of any 740 whistleblower claim. So what the lower court found was that reading the complaint on its face, the allegations assert only the New York State Human Rights Law disability discrimination and retaliation claims, and not an independent cause of action for 740 whistleblowing.
Does that have to do anything with the, I'm sorry, does that have anything to do with the timing of the termination notice versus the filing of the complaint before human rights, state human rights?
Only with respect to the New York State Human Rights Law claims. So once the appellant filed with the State Division, he's exclusively chosen the jurisdiction of the State Division for purposes of all his human rights law claims, which are the only claims that the lower court found to be pled on the face of this complaint.
Justice Kapnick?
What happened, at what point did the plaintiff file a statement about retaliation against whistleblower? He put in a separate statement later on. Is that what he did?
No, Your Honor. This complaint with the lower court, according to appellant, provides some sort of relief under the whistleblower law. That was only raised in opposition to our motion to dismiss based upon the election of remedies doctrine.
So your argument is that there's nothing on the face of the complaint which alleges any type of claim as to a whistleblower?
Correct. And to the extent, and just for argument's sake, if there was to be found, if the court did find, with a generous reading of the complaint that's afforded pro se plaintiffs, I appreciate that the complaint nonetheless fails to state a claim for 740 whistleblower because there's absolutely no causal connection between the adverse action and the purported protected activity. The purported protected activity took place during the termination meeting.
So he was notified on July 21st that he was going to be terminated on August 1st, and that is at the time when he said that he was going to the Department of Labor.
Correct, Your Honor.
When was the probation extended? When was his probation? Was it at some point in time his probation was extended?
I don't recall the dates off the top of my head, Your Honor, but there is no allegation that an extension of probation is the adverse action here, and appellant has provided no case law, and I'm not aware of any off the top of my head that simply an extension of a probationary period under the state human rights law would constitute an adverse action.
Thank you.
Thank you, Your Honors.
Yes, so you have rebuttal?
Well, I do have an evidence presented by Mr. Justin. Sorry if I misspell your last name, sir. Mr. Justin Golifoya. Sorry if I apologize it wrongfully. So I do have evidence from Mr. Justin Golifoya on December 2023. That's around 6 months after my termination. He agreed to pay the charges for stealing the wages of 11 employees to the Department of Labor. At that time, Mr. Justin didn't argue with the Department of Labor while they're getting investigated for stealing and misclassifying the job. They didn't argue that they already got charged in response to the Department of Human Rights complaint, which was done by August and October. So I filed the charges with the Department of Human Rights in August. By October, Your Honor, their response, in December, Mr. Justin agreed with the Department of Labor, I have it here, that they stole wages of 11 employees, misclassified the job. There was no argument that this is a separate claim. There was no argument with the Department of Labor that we already got charged with discrimination and retaliation. Additionally, Your Honor, I can answer the question about when the appropriation has done. It's right exact after I request the accommodation. It's happened right after that. Right before that, they were thanking me, and I met Miss Karen, which is the vice president of the hospital, to ask me for being a voice of a patient from Saudi Arabia. Has a cancer, she cannot talk, and I was there in the hospital all day with her.
Thank you. Thank you both. Fidelity National v. Sky Abstract. Yes, proceed, please.
Good afternoon. May it please the court. The appeal turns on a straightforward application of Racket versus Brown. That's the case that both sides relied on in this case. Court of Appeals, in the companion case Zangi, that's discussed in the Racket case, stated expressly that in that case, Zain, who was the building owner, hired the contractors, designed and constructed the addition, including the contractor who erected the canopy roof. So the building owner hired this person. Tenants had no relationship with those contractors at all. That the court still allowed indemnification because the tenant's liability was purely derivative of the contractor's negligence. That's exactly our posture. My client's liability arises solely because he guaranteed Sky's obligations as—
Can I ask you, is the guarantee in the record on appeal? Is there a signed guarantee in the record that you presented to us?
I believe so.
Because I didn't find it, so maybe you can point it to me. But I mean, was your client, you represent Mr.
Gunslinger, correct.
Okay, so was he the owner of Sky Abstract?
Okay, so he was sort of like an investor. He invested in this an abstract company. Basically, someone else was running it. So all he did was he signed that if there are any claims against Sky, then Fidelity could go after him.
I mean, you usually don't just get somebody unrelated to come in and sign a guarantee that if anybody brings a claim against Sky, that they should go to him. He signed this guarantee, allegedly, that he would be responsible.
Right. So he said so, but he just backed up Sky.
And you're stating that his relationship to Sky is that he was simply an investor?
He was like he had a small percentage ownership of Sky.
So does Sky still exist? They don't seem to be involved in the litigation of this case.
They're defunct.
So Sky is defunct. As of when, as of when they were defunct, is that in the record?
It's been years, and it's been years. And so by the time these claims came, they couldn't go after Sky, so they went.
So you're saying that there is enough of a contact, enough of a relationship here for the indemnification claim to be considered?
No, what I'm saying is that according to the Racket versus Brown case and many other cases, you don't have to have a direct relationship. You don't have to have a direct sort of privity between you and the other party. The main thing in an indemnification case is that you shouldn't be held responsible for someone else's wrong. In this case, there was a fraudster who cheated the bank.
I mean, all the cases that you both rely upon are all personal injury cases, which really don't seem to have seem to be very different type of relationships and indemnification issues than would be in this type of an unusual situation.
But over here, we're dealing with torts in this case as well. In other words, Kunstlinger the only thing, he didn't do anything wrong. All he did was sign as a guarantor. And because of that, he ended up paying.
He's responsible because Sky never arranged to get the mortgage filed, which became a big problem, didn't it?
Sorry, what was
Sky never got, Sky or Nationwide never filed the mortgage, right?
Oh, so, right, but he's not Sky. He's saying that Nationwide had the obligation to do the filing, and he didn't do it.
And Sky
So
can't
Sky
sue,
Sky should have an indemnification claim against Nationwide as well.
but
And-
Sky is
and-
defunct and Sky cannot sue Nationwide. Sky cannot sue Nationwide because they don't exist anymore.
Right, okay, what I'm saying, but Kunstlinger is not any worse than Sky, and Kunstlinger just was, the only thing he did was he signed the guarantee. So the concept should still apply, even if it's not like the typical, let's say, labor, injury case.
Right.
We hear it was, he didn't do anything wrong, and the way the cases read, many of the first department cases say the same thing, Court of Appeals cases, that the main point over here is that you have an indemnity claim if you didn't do anything wrong, and you should not be held responsible for someone else's wrongdoing. So you should be able to go after the party that committed the wrong and try to recoup.
Thank you.
May it please the court, Your Honors, Lee Schneider on behalf, from law firm Kelly Jasons, on behalf of third-party defendant, respondent, Nationwide Court Services. Just to pick up on the prior questioning, everyone seeking indemnification, in essence, is arguing that they did nothing wrong.
Well, I mean, at least in this case, Sky hired Nationwide to file the mortgage, right?
Allegedly, yes.
Okay, allegedly. And Mr. Kunzler, he simply signed the guarantee. So he definitely did, quote unquote, nothing wrong, right? Because all he does is sign the guarantee. So it's either Sky or Nationwide, right?
Yeah, well,
Because it was responsibility of filing the mortgage, and no one did so. And it was not done.
Yeah, that would, if assuming the fact's true, that would be correct, but it doesn't.
Was there anything to suggest that Mr. Kunzlinger was in any way responsible for filing the mortgage?
I have no knowledge the discovery didn't even happen in this case.
Is there or was there a written agreement between Sky and Nationwide?
So Sky and Nationwide had a relationship where they were used. Nationwide was used to record mortgages for Sky in various cases over the years.
Right.
And we actually submitted in support of our motion to dismiss, which the trial court judge didn't need to address because he dismissed the claims on a legal basis. We submitted evidence that in this particular instance, there was actually not even a request from Sky to Nationwide to record this specific mortgage. They have their entire database that they searched, and they have their mechanisms for doing so.
Yeah, but was it common for Nationwide to file these mortgages? I mean, was this like a relationship that they had where they would do so?
Yeah, this is part of their
For
business.
Sky?
This is part of their business, and Sky was one of their customers that
Right.
they would do this for.
So you're saying you put in evidence, but you just said that this is a motion to dismiss. You put that in to support why you wanted to dismiss. Don't we need to have some discovery here?
It was an alternative argument based on CPLR 3211A1 based on documentary evidence.
Right.
Our main argument was that there's no relationship between the proposed indemnity and the proposed indemnitor, which is what all New York State case law requires.
So that's, you're saying there's no relationship between whom?
Between Nationwide and Mr. Kunstlinger.
But if Mr. Kunstlinger was the guarantee of the actions of Sky and you had a relationship with Sky, isn't there at least an issue of fact that there was enough of a relationship here? Because he's now responsible for what Sky did. Sky doesn't seem to exist anymore. They're not litigating. They don't exist. So why should he just be out there having paid having been forced to pay when he did nothing wrong except guarantee, doesn't he have the right to come against you like Sky would have had the right to come against you, except they don't exist anymore?
Well, no, Your Honor, because there's no first of all, there's no allegations in the complaint that there was any such sort of close relationship which would tie Sky to Mr. Kunstlinger.
So what about the guarantee?
Yeah, it's a separate side deal that Sky made.
There are a lot of side deals in this case, but you're
There's
no guarantee here?
nothing in the complaint. The complaint does state that Mr. Kunstlinger guaranteed the loan, the mortgage.
Yeah, Mr. Kunstlinger took the risk of guaranteeing,
Right, so-
of guaranteeing a loan for a now defunct company.
Right,
That's-
so that satisfies the need for something showing that there's a relationship between Kunstlinger and Sky.
I'm not sure that's true at all, and I don't think that's what the appellant is even arguing in the case. He's arguing that there's no relationship that's even required at all.
Counsel, if I may, what is the response to appellant's argument that equity requires Nationwide to indemnify the appellant because Nationwide is the alleged wrongdoer and certainly appellant is required to pay and he didn't do anything wrong?
Well, among other things, this all happened 20 years ago, right? So we're dealing with a situation where an entity such as Nationwide, who by all intents and purposes, at least as far as the record goes, has no knowledge that Mr. Kunstlinger even exists, is now held liable for based on a guarantee agreement that it does not know exists, for in the event that Sky Abstract is no longer available to pursue its own claims on behalf of itself, that 20 years later, after this alleged circumstance took place, that it will one day be required to pay out on a title insurance policy on a mortgage.
Can we figure all that out on a motion to dismiss?
Right, why, I mean, because everything you're saying, you said, well, we don't know if Kunstlinger exists, we don't know the relationship. Wouldn't we know these things after discovery?
There was no allegations in the lawsuit that there was any relationship between in the complaint that there was any relationship. I take your Honor's point that there is no allegation that there was a guarantee agreement.
Yes.
Right.
But the appellant is arguing that the case at the lower court turned on the fact that no relationship was required, which is blanketly untrue. Clearly, there's a relationship that needs to be in existence for someone to pursue
No
identification.
contractual relationship is required.
Right.
There is a relationship is required.
It even doesn't have to be contractual. It could be common law indemnification as well.
Right.
Based on the fact that there was no communications whatsoever in the record or known between Mr. Kunstlinger himself, the proposed indemnitor, and the proposed indemnity and Nationwide, the indemnitor. That was part of our reason for dismissal. And if I could add one more thing on the fact, there's another mechanism that could have been pursued that was not pursued, and that is contribution. Two people argue that they both, one person argues that another person contributed to the harm, right, which would not require this direct relationship. It would require that both people would have a direct relationship between with the plaintiff in the lawsuit. So it would have to argue that Nationwide had an obligation to the plaintiff, that Mr. Kunstlinger had an obligation to the plaintiff, and the two of them together should fight it out, determines who's actually liable. The problem is now that claim is dismissed because under general obligations law 15-108, those claims are extinguished by a settlement, which is my understanding is what happened between Kunstlinger and Fidelity, the plaintiff in the underlying case.
Thank you.
Okay, so at the end of the day, if you look at the racket case, and as clarified by Zangi, in that case, it was the building owner hired the contractor that built the defective roof, whatever, that the people got canopy that caused the injury. Nevertheless, a third party, the tenant, who had no connection with that with the Canopy Company was able to sue an indemnity. It's clear from these cases that the indemnification does not require some type of, there is a concept of contractual indemnity, but there's also common law indemnity. Common law indemnity, the requirements just means that the duty that was owed by the wrongdoer is that they should not do a bad thing. So the duty is that they did a bad thing, either was the fraud or was not recording the title. And therefore, all these cases say over and over again that we shouldn't hold a person that didn't do anything wrong responsible if someone else is more correctly the party that should be responsible.
Thank you.
Thank you.
Narez v. 12 West 31st Street. Yes.
Good afternoon, Your Honors. May it please the court, Travis Wong for the plaintiff appellant. In this case, we have a single instance of law office failure that occurred when plaintiff's counsel did not update his calendar when he stipulated to a certain date. That resulted in defendant's motion being submitted without opposition and then being subsequently granted and plaintiff's entire complaint being dismissed. Within 6 days of the order vacating, plaintiff moved to vacate. Plaintiff's motion was denied, but it was erroneously denied because it's respectfully submitted that plaintiff did submit a reasonable excuse. Plaintiff explained in detail that he had relied upon the dates on e-courts to populate his calendar, and that his failure to, what he should have done, update the date based on the stipulation, resulted in him not being aware of the due date. So with that detailed explanation, it's respectfully submitted that the law permits for this one-time instance of law office failure, and that is especially crucial in light of plaintiff's continued concurrent motion for summary judgment, as well as his continued efforts.
There was no indication that you intended to abandon the case, since there were still motions pending, and you waited just not even a week to make the motion to vacate, right?
Exactly. Additionally, plaintiff demonstrated a meritorious cause of action. This is clearly a labor law section 240 sub 1 case. Plaintiff was working on a external fire escape and was caused to slip on.
He was actually working on it. He wasn't using it to pass through. He was welding some kind of handrail onto the actual fire escape.
Exactly. It was one of the spindles, which I had to look up. But the spindle, he was welding, and he was actually working there. It was the functional equivalent of a scaffold or elevated platform, and therefore a safety device under the law.
And it's different from a staircase because it's a fire escape?
It's different from a staircase. I think more so because he was required to work on it, and because it's a fire escape. And there's a number of cases that were cited in our brief that demonstrate where a plaintiff is required to actually work at a height from a fire escape. That constitutes a safety device.
And also there are cases that stand for the proposition that a fire escape does constitute an elevated surface, right?
Correct, yes.
Thank you.
Thank you.
May it please the court, on behalf of defendant respondent Patrick Shelley, Curly Walsh, Matera, Cinquemani. I think the issue is a little more complex than what plaintiff makes it out to be. I think the court properly denied plaintiff's motion to vacate. The attorney who was responsible for submitting that position crafted the stipulation, set forth the schedule, and then failed to comply with the stipulation.
And that's never happened to any defendant.
I'm not saying it's never happened,
right?
Your Honor, but it's instructive in that the defendant respondent had submitted their opposition to plaintiff's motion in a timely fashion, and plaintiff's reliance on the e-court system is misplaced because the e-court system would only provide the ultimate return date for the motion and not the prior date for which his opposition was required. So the excuse that plaintiff relies upon is not reasonable, and that it's crafted in a way that even if it functioned as intended, would not be possible. The court system would, if the plaintiff had submitted a stipulation and assumed it was accepted by the court and went by that schedule, that would be a reasonable excuse.
How was your client prejudiced?
I don't think that the law requires that to be an issue. He has to submit a reasonable excuse.
But I'm asking you. Okay. Because, I mean, that's some of the factors in deciding whether or not to, vacate a default. So that's the question.
I don't know the answer to that question because that's not contemplated in this situation from what the case law that I've read. The underlying court properly took into consideration these issues and denied plaintiff's request and found their argument wholly insufficient.
Did you argue that there was prejudice?
I'm aware of that argument, Your Honor.
I mean, the thing that's so weird about this case is the judge made a decision on October 31st on your motion to dismiss plaintiff's complaint, and that was granted because there was no opposition. The very next day, October 31st, November 1st, that's the very next day, the judge issues another decision in which she considers plaintiff's motion for summary judgment on liability, and she denies it, but like she had just dismissed the case the day before. So it seems like everybody was a little confused about what was going on, but there was a pending motion on the merits that hadn't even been decided, on the day that she dismissed the complaint without opposition. I think it's clear there was some mistake here. There was no intention to abandon the case, and that we do like to try to decide cases on the merits, which I think kind of goes to Judge Kennedy's question about, what's the prejudice? I guess the prejudice, we would have won, but that's really not the right thing here. And so this is kind of a mess, and don't you think we ought to sort of start on the merits?
I understand it's a mess, but if we're going to address the merits, we should consider the following: that the plaintiff, in setting forth their meritorious cause of action, doesn't rely on any affidavit of merit from the plaintiff, only relies on their summons and complaint and the bill of particulars, which were unverified. The deposition transcripts submitted by the plaintiff were not executed by the plaintiff. There was an interpreter that was used during the deposition. So understanding the First Department would allow him to use those transcripts. The extra element of the fact that we can't rely on the testimony of the plaintiff himself because it was translated. And it's instructive to note that the bill of particulars and the summons and complaint talk about a fall from a ladder, where the plaintiff's testimony talks about slip and fall from a scaffold. And the fact that the plaintiff relies on the argument of a functional equivalent, that the fire escape is a functional equivalent of a scaffold. The line of case law that allows for that to happen requires that there be a defect on the functional equivalent item, the safety device. Here, there was no allegation there was anything wrong with the fire escape, and therefore the plaintiff cannot rely on that functional equivalent language to set forth their meritorious cause of action. So if assuming the plaintiff has a reasonable excuse, they still fail to prove the meritorious cause of action in that they haven't set forth the factual basis based upon their client's, the lack of merit that on behalf of their client or their pleadings, and the case law would not support a 240 subsection 1 claim.
So in terms of the plaintiff's deposition testimony, did you not use that or attempt to use that in your motion for summary judgment?
I'm glad you brought that up, Your Honor. Yes, I did. I did use that in my motion, but pursuant to the CPLR, I sent a letter to plaintiff's counsel saying that if you don't sign this, execute it within 60 days, it's deemed verified. So for my purposes, it is deemed verified. For his purposes, where it's his burden, he shouldn't get the benefit of using that transcript where the case law relies upon his own client's statements when his client was also relying on an interpreter to set forth his claim. There's issues in the transcript, if the court looks at it, where it's unclear as to some translation. So now we're going to further allow an area where the plaintiff has a gray area to assume certain things and not others, and I don't think that's what the court is allowing for.
Justice Kapner? No.
The only other issue, Judge, if I could, is that it's clear the only merit the plaintiff set forth in their argument is under the 240 subsection 1 claim. It's the defendant's position that the 200 and the 241-6 claims would be deemed abandoned and that the plaintiff didn't set forth any merit in that regard.
Thank you.
Thank you, Your Honor.
But what about the abandonment of those other two causes of action?
They're abandoned. They were not, they did not, we did not move to vacate. We only moved to
Okay.
vacate on the 240 subsection 1.
Just want to clarify. Thank you.
I just would like to address the transcripts. Plaintiff is able to rely on his own transcripts in moving for summary judgment. The law is very clear on that. I cited Nyambu v. Whole Foods in my brief on page 16. Additionally, defendant raised issues about the bill of particulars. That was nowhere in the brief, so I can't address those issues, and I don't think they should be
What
considered.
about the transcription and the interpreter, the use of the interpreter, and apparently there are issues in terms of translation?
Any issue would be apparent on the record, and the transcripts are often translated and often relied upon, even unsigned transcripts, by a plaintiff when moving for summary judgment. I believe the case law is very clear on that issue, and I think in this case, plaintiff has demonstrated entitlement to summary judgment on the issue of labor law 240 subsection 1.
Thank you.
Thank you.
Canalis v. Noble Construction. Whenever you're ready.
May it please the court, my name is Nick Favanti from Fabiani Coleman Hall, representing the appellant respondent, Noble Construction in 350 East Houston. The common law negligence and labor law 200 claims.
So was Noble on site at the time of the incident?
They had minimal employees there. I believe there's 3.
Was it Mr. Palmieri, I think?
It was one of them, correct.
So one of the issues, I guess, is what, if any, connection or instruction did Palmieri or anyone from Noble give to Sousa or the plaintiff in terms of carrying this 800-pound box?
Palmieri gave no instructions at all. Sousa never said he did. Neither did plaintiff.
Who's Mr. Pita?
Yeah, Mr. Peter apparently works for Noble.
Mr. Peter?
Pita? Didn't he give it an
Peter,
affirmation?
yeah, doesn't he? He works for Noble as well, right?
Pita. Yes. Yeah. He says that
Yeah, he stated that he corroborated the plaintiff's testimony as to how the incident occurred. He also stated that that I think Palmieri.
Palmieri was involved in the decision, he says.
Yes.
He didn't say how he was involved in the decision. He said that D'Souza told the plaintiff to move the object, but he didn't say that he heard Palmieri say it. D'Souza said...
Well, he says that Palmieri was involved in his decision.
That's all he says. He didn't say how he got that information about how he was involved. He didn't say he heard him say that. There's no information besides involved.
Was that enough to create an issue of fact as to Noble's liability or possible liability?
I don't believe it is, Your Honor. I mean, as far as we know, it's just more hearsay from D'Souza, from PETA, from the plaintiff about someone else telling him that Palmieri said that, to move it. Palmieri himself testified in an affirmation and in deposition that he did not instruct them to move it. He said it was up to the contractors, including Team Electric, how to accept deliveries of their...
Yeah, but Noble was responsible for coordinating the subcontractors and how they took deliveries to the site.
Scheduling
when the deliveries were made and coordinating, et cetera. I understand Mr. Palmieri specifically stated that they didn't tell them, how to do the work or how to unload, et cetera.
Yes.
But they were responsible, Noble was responsible for coordinating
Yes,
the
but
deliveries.
again, but that doesn't rise to the means and methods of how to unload this 800-pound end box.
Well, the thing that seemed confusing to me is that this end box, I think that's what they call it, this was an electrical thing. And on the day that it was delivered, there were one or two, depending on whose testimony you believe, electrical guys there, but they needed 8 guys to move it. So they used the concrete guys, and the concrete guys used their Bobcat, and then they had to manually pick up the end box at some point and move it, which is when the injury occurred. So Noble is the GC on the project. Shouldn't they be coordinating that the deliveries come when the correct people are there? How do they, I mean, there seems to be a lot of different people testifying about a lot of different things. When it's taken all together, how do we let you out of, of 200 at this stage of the game?
Again, because we did not actually exercise supervision. Under First Department case law, you actually have to exercise supervision. Even if they have the authority to, they actually have to do that exercise to be considered.
But isn't there some testimony here, even if it's partially hearsay, which we do, consider on a summary judgment motion if there's other testimony, all put together, create at least an issue of fact as to whether or not, in fact, anybody from Noble was exercising supervision over the work that was done involving this end box on the day of the accident?
Again, I don't think it was partially hearsay. I think it's completely hearsay. And that is
Well, I mean, he says that it's kind of unclear because he says that Palmieri was involved in the decision. He doesn't state how he knows that, but he says Palmieri was involved in the decision.
Yeah, I mean, Pizza says that Noble, his affidavit claims that Noble was involved in the decision to have C&L Concrete move the electrical box.
Yes, Your Honor. I mean, I also want to point out that it's our position that entire information or affidavit is fraudulent.
I understand it, but then that becomes a credibility issue because there's an issue about was he really there, he didn't swipe in or something like that. I mean, there's so many issues here that it's not the kind of thing we usually resolve on a summary judgment motion. That's what I'm saying.
Yeah, I disagree with that. I think it's clear that there was no exercise of supervision. If I have a minute to go over 241-6, or should I do that in rebuttal?
Thank you. You have time, brother.
Good afternoon, Your Honors. May it please the court. Lisa Como for the plaintiff, respondent, and cross-appellant. I'd like to address the 240 issue, if I may. I think that this case is actually a very interesting case with respect to 240. The lower court said because the object, which was very, very heavy, and which everyone, I think there's really no dispute on this record, sort of as an aside, that it required hoisting equipment. Even the defense witnesses said that. The witness from C&L, whose equipment
That's how it was delivered to the site. It was originally delivered to the site using a hoisting.
Right, and he said it requires rigging. It's the kind of thing that you clearly anticipate is not something that should be moved by hand.
Even by 8 guys.
Yeah, you know what, I know I shouldn't really make a joke, but it just reminded me of those old movies with them building the pyramids and like moving the big blocks. It's like no matter how many people you have, sometimes you just can't do it and you just shouldn't do it. But in this case, this is like an 800 to 1,000 pound.
But they erected the pyramids, though.
I don't think
probably a lot of guys.
I don't know how
They
many.
didn't have 240.
They didn't have 240.
See, if they had 240 in ancient
240
Egypt,
cases
yeah.
you would have had with the pyramids.
Okay, maybe it was a bad analogy, but the point is that no matter how many people you have, sometimes you just, where do you draw the line?
Well, I mean,
when
it's
you say you
800
need it?
pounds, so it's interesting that they, they used the hoisting and then they like bring it to the threshold.
Because they couldn't get it
Because they
around,
get it-
right?
Because
The
they
last
couldn't get it
part.
around. So you drop it at the threshold and it's like, okay, well, now you guys
now
figure out how you're
go
going to
do it.
Yeah.
I think that actually what's at the heart of all of these claims is what they like to call the job hazard analysis. And we submit, it's in our brief, and I have very little time, so with respect to the 200, I would submit that On this record, there are certainly questions of fact as to whether Noble should have done that job hazard analysis, that they would be the party responsible when you're putting two of your subcontractors together to perform a task that they wouldn't normally be doing otherwise, and that's not necessarily like.
I mean, who's the one that said, okay, get the concrete guys to move the electrical box? I mean,
The plaintiff testified, there is some hearsay, but it's a chain of command type of hearsay. But it's important because it's like the foreman comes and says, the electrical guys need help, and the Noble supervisor said that we should go and help them, and this is what we're going to do.
Well, you know, it's interesting also because Mr. Palmieri states that he was present. I think he states that he observed everything and he didn't see it fall. And he said he saw them carrying it and he never saw it fall on your client. The only one who says that, I think, I didn't even know that Sousa even saw it, but Peter really, Pila, right?
Yeah, but
Peter is the
there's
only one who actually states. And also, Palmieri states that your client, you know, it wasn't reported to him until I think a week or so after the incident.
But there is an incident report that's in the record that does memorialize it, and that really was not an argument that was made here. They were not really genuinely disputing that. It's not been briefed, and I think that it's very clear. We have eyewitness testimony and certainly plaintiff's testimony. But just back to the 240 issue itself, it's exhaustively briefed from all sides, I think. But I would like to say that I think the case that is really the most similar to this is a case from the Second Department called Gutmann, which is cited in both of our briefs. And there's also a recent case from this court from December called Rivera, which we cite in our reply. Gutmann is interesting. That was actually my case from many years ago in the Second Department, and it was a very, very large, like a beam that was being put in place using rail hooks, which is just like a manual hook. So it's almost like holding with your hands, but you have a little bit of help, but no hoisting device. And it was almost exactly the same sort of thing. You have a bunch of guys who are moving this big thing. It's about 4 feet up, and somebody trips. And the Second Department did say that it was a question of fact as to 240. I would submit that it is at least a question of fact here, and that this case is really even stronger because it's undisputed that hoisting equipment was required, that it was not safe to do it this way. And also, with respect to the question of what brought about the need for the hoisting equipment? Now, the court below said, well, you know, the whole thing was put in motion by someone tripping, and so that's disconnected from 240. However, going back to the job hazard analysis, when you have a situation where you have this very narrow, I am going to call it a passageway, and quickly reference the 241.6, I think it clearly under the case law, this is a passageway, and that conclusion was appropriate. But with respect to the obstruction, that should be part of the job hazard analysis, which is part of your 240 analysis when you were there, sort of boots on the ground, deciding what equipment is needed. You have to take into account the need not just to hoist it up by hand to a certain height to move it, but to also traverse this obstacle, which is going to require someone to step over it.
Right, it was rebar, right?
It was rebar, and
that the person apparently
it was a foot and a half.
Yeah, that was hanging. Yeah.
And the testimony was that he got tangled up in it.
Yes.
So
thank you.
Thank you.
Good afternoon, Your Honor. Eric Bailey, Bartlett LLP for Team Electric. Just briefly with regard to the 240 issue, as the court below held, this was a trip and fall while walking on a flat surface. It was not elevated. It is the kind of injury.
What about the fact that this was an 800 to 1,000 pound, that's the testimony I read, end box. It was being carried by 8 guys, and that many people said that they needed some type of equipment to hoist that this is not the right way to have done this movement.
It may very well not have been, Judge Kamnick, but the issue here is, did the accident result from a gravity-related hazard? The injury arguably did, not the accident. The accident arose from tripping over rebar.
Can there be more than one way? Can there be more than one proximate cause for an injury to plaintiff?
There can be, and in this case, there were multiple causes for the plaintiff's injury, none of which relate to 240. Plaintiff was injured because of the fact that CNL was directed by Noble, and then CNL directed its employees to move the box, knowing that it had to be moved by hand. Noble is also responsible because Noble had in its policy, as said by Mr. Palmieri, that if there were not members of the particular trade, in this case Team Electric, to move the box, that they would either turn away the delivery or wait until Team Electric personnel were there. Here, Noble made the decision that it would be removed and delivered in violation of their position, which creates affirmative negligence on their part. In addition, the rebar, according to Mr. Palmieri, was installed about 3 weeks before the accident. The health and safety plan requires Noble to inspect at minimum once a week, and yet Mr. Palmieri testified that Noble didn't do that. Noble didn't make sure that the delivery, which was in the manner that it was being provided, would be allowed to be done, and that there wouldn't be an obstacle, and all of that then goes to the responsibility of Noble. That said, on 241-6, under Spencer versus...
Counsel, may I?
Oh, yes.
I'm over here. Hi. I have a question that concerns force of gravity. So to the extent that a hoist apparently was necessary in order to move such a large, heavy object, why doesn't this fall under 241?
Well, it doesn't, because 241 really, as the court below found, only a tripping hazard applied. They only found 23-1.7E. And the fact is that in this, the case law holds that a co-worker tripping does not constitute a violation of that regulation.
But aren't you leaving out an important part of it? A coworker tripping while carrying helping carry a substantial object that should have been moved by a hoist. I mean, there is an elevation. Is there an echo on your end, or is it just on mine? Okay, just on mine. Okay. There is an elevation to the extent that the 800-pound end box is lifted up in the air, and you know that we don't have a height requirement. So under those circumstances, why isn't this under 241? 6.
Because that's
241, 241, sorry.
240
Huh?
sub 1 or 241
Yeah, 240 sub 1.
240 sub 1.
Thank you, 240 sub 1.
Okay. With regard to 240 sub 1, the fact is that what happened in this case was an ordinary trip and fall. Now, yes, they were carrying something heavy at the
Ordinary trip and fall is I slip over something that's at my feet. But the red light is on, so.
Okay. Your Honors, can I briefly address the indemnification issue?
Very briefly.
What was that?
Very briefly.
Yeah. With regard to the indemnification issues, there is, first of all, ample evidence based on the things that I referenced that Noble was at least in part negligent, therefore not entitled.
That would be premature for indemnification at
Right.
this
It would not be entitled to indemnification under either common law or the contractual. With regard to contribution, there has to be evidence of negligence on the part of Team Electric, and there is no evidence that Team Electric was even present and able to participate in the work that was ongoing at the time of the accident. Referencing work with regard to contractual indemnification, there were two triggers. One was the negligence, one was rising out of the work. However, the definition of work as it applied to Team Electric's contract was not provided to the court to determine summary judgment. The fact that the court made a determination implies that this is something that the court would have had to see, would have had to make a determination if it was going to find indemnity or contribution under this trigger. The contract being incomplete was prima facie defective and cannot establish that this arose out of the work of Team Electric.
Thank you.
Thank
you. Good afternoon. May it please the court. Joel Sweetbaum for the respondent, CNL Concrete. Based on Your Honor's questions, I submit that the court below was absolutely correct in denying the contractual indemnification claims of Noble against CNL, and that Team Electric's contribution claims, that CNL's contribution claims should remain against Team Electric. As Your Honors stated previously in the questions that were asked, because of the conflicting testimony, which is clear throughout the record, issues of fact were raised as to Noble's liability of negligence, as well as Team Electric. Taking everything together, there is absolutely, I submit, factual issues of the supervision that Noble exercised or should have exercised, and the partial hearsay was absolutely correct to be considered. I think the court below, in the various parts of the decision, stated that, based upon the summary judgment papers, the court could not determine who directed CNL Concrete to help out with the unloading of the electrical box, and the deposition testimony from the various witnesses supports many different interpretations. Based on the record below, I submit that there should be no reversal of Noble's claims against my client CNL, and that CNL's contribution claims against Team Electric should remain in full force and effect throughout this litigation.
Thank you.
Thank you.
A few things, Your Honor. First, there were Team Electric employees on site when it was delivered.
Well, we don't know. They said there may have been one or two, depending upon the record.
Even one or two is people on site. And they were responsible for taking delivery. Regarding the 240 claims, there are other cases where people have been carrying loads, tripped and fell, and there was no violation in those claims.
Well, so plaintiffs submitted a report from their expert stating that a hoisting device was necessary, should have been used. Did you put in anything to refute that?
Well, the plaintiff's expert did not, while he said that it should have been used, he didn't explain why it should be used. There's no guidelines. He said how heavy, how far. If he's moving it a few inches over, is that required for hoisting? Is it 500, 800? There's no guidelines submitted by
Counsel, did your expert say that?
I didn't have.
They didn't have an expert. They didn't have, that was, they didn't have an expert.
That was the answer to the question, right? There was no expert on your behalf.
That is true, Your Honor, yes. There was no expert on our behalf.
Well, he did say that it fell a significant elevation, a physically significant elevation differential. So he did opine somewhat in terms of the elevation.
But he didn't define what a significant elevation is. We don't, there's no guidelines, there's no rules about based on.
I mean, those are also things that we've decided in our legal cases. Even if it's not that high up, if it's a big item, 800 pounds, and it falls, then that could be a significant elevation differential. And that's what the cases have said. If it's a little thing, that's different. But if it's a big 800-pound thing, even if it's only a few feet in the air, there could be a significant damage. So
again, though,
that's what.
Counsel,
look, you didn't have an expert that.
Right.
Nobody had an expert that that you put in. So we just have plaintiff's expert.
Again.
And counsel, if I may, counsel, and the plaintiff's engineer also said that the end box was hoisted several feet in the air. So there is some type of measure included in his expert opinion.
Again, it didn't say how high hoisting would require. There's no guideline saying above 2 feet, above 1 foot, or we don't know how high several feet high
Thank
is.
you.
Thank you, Your Honor.
Just to pick up on that thread, if I may, I would like to emphasize again that the plaintiff's expert's testimony, affidavit, is based on the testimony that's in the record. The plaintiff's testimony that it was at chest height when it fell, so that no one knows exactly what height that is, but it's at least several feet.
Several feet.
Several feet, certainly. And Mr. Anastos from Team Electric, his testimony, the expert agrees with his assessment, and he's very experienced in moving these things, which, again, we talked about before, that rigging is required, hoisting is required. He would never move this any other way. It just wasn't the way it was done. And part of it is a common sense, experience-based opinion, which is perfectly valid for an expert like Mr. Silverberg, who's a professional engineer with also many years of hands-on construction experience, where he basically said that, it's his opinion that you don't do it this way. When something is this heavy, even if you have a bunch of guys, which is what we had here, when you take into account in particular as well that tripping hazard, and that they have to not only pick up the thing and move it from here to there, but there's something in the way that is in the way when you're doing that job hazard analysis in the first place.
Thank you.
Thank you very much.
Your Honors, as you correctly pointed out, there was only one expert in this, only one person who said who was responsible for what happened. And that expert did not name Team Electric as being negligent in any manner in causing the happening of this accident. With regard to CNL's complaint against...
It's Team Electric's box, right?
It was Team Electric's box, but Team Electric did nothing with the box, number one.
Didn't a couple of the guys, the testimony I thought was that there were 1 or 2 guys from Team Electric there the day that the box was delivered. Didn't they help deliver it with the concrete guys, or they just went off doing something else?
They were not involved in that whatsoever. The testimony was, let's put it this way, the CNL people said that they don't even remember whether a Team Electric person was in the vicinity of where the accident
They didn't remember, they don't know for
That
sure.
doesn't mean that they weren't.
But they did not, they did say they didn't get directions from them, and Team Electric had no authority to give them directions.
Thank you.
So
Thank you all. Almadova. The City of New York. Yes, counsel, whenever you're ready.
Good afternoon. May it please the court, Jimmy Wagner for the appellant plaintiff, Jason Almadova.
Almadova.
Before we get to the underlying merits, first things first, the statute of limitation argument, which the lower court had dismissed my client's complaint on. Respondents concede that was the wrong order. It's incorrect. This court has since, on 2 different occasions, said that absolutely not. Statute of limitations shouldn't have been applied on this case. Once we move past the statute of limitations, I want to talk about Judiciary Law 21 and Judiciary Law 9. This case was originally signed to Judge Kim. She heard the motion, the 3211 motion, on oral arguments on the record. We had a transcript. The motion sits for over a year and then allegedly is administratively reassigned to Judge Kingo. That is practically what's called a constructive recusal. And I think in 2020, our legislature...
Well, I'm sorry, how do we get to a practical recusal? How do we get to
constructive recusal? An administrative reassignment with no excuse of any type.
I'm sorry, so what is that based on? Is your case law something that would term it as a constructive recusal?
I don't know how else to phrase it because the judge didn't...
Why do you phrase it that way?
Because the judge was recused from the case.
No, the case was assigned to another judge. That doesn't constitute a recusal. I don't think that's the definition of a recusal under the judiciary law or any law.
I think it's actually a method used by New York County Supreme Court to have a judge avoid their obligations under New Judiciary
Well,
9?
counsel, you know what? I don't believe that that is correct. So why don't you move on?
So then let's move on to Judiciary Law 21.
Yeah, let's do that.
That's a great idea. So Judge Kingo had not heard a single instance, hadn't heard any of the factual
But
arguments.
he did have a transcript to review,
He
correct?
did not have the transcript to review. I didn't upload the transcript till after his decision. He did
Counsel,
not have
if
the
I
transcript.
may.
He didn't have
If I
it.
may. We're talking about Judiciary Law 21. And my question to you is, how did Justice Kingo, engage in fact-finding, as you claim, when he only indicated that the plaintiff did not plead sufficient facts to support an inference of discrimination? To me, that sounds like examining the complaint, not making any fact-finding.
That's an incorrect understanding of Justice Kingo's decision, because what Justice Kingo said was there was no conflict between his constructive termination and his denial to take the vaccine. However, in a case that's going to be before this court tomorrow in Kronmeier, Justice Kingo found in an almost identical fact pattern that particular individual,
I want to go back.
Conflict.
I want to go back. So is it fair to say that when a court indicates that a party fails to plead sufficient facts, it's your contention that that is a factual determination and not a legal determination?
No, that's an excellent question, Judge. Determining if
That means I'm going to get an excellent answer then.
I hope you get an excellent answer. I don't know about in the First Department, but the conflict, the determination of a
You don't know
conflict.
about it in the First Department. What do you mean? What do you say?
I find in the First Department, statutory law is underneath precedent of this court. The First Department, in my
So,
opinion,
counsel,
doesn't follow.
do not criticize the cases in this department. If you have a problem with a decision in this department, then you take it up to the Court of Appeals, which you have done repeatedly and lost. So let's stay.
I was asked a question and I answered it, Your Honor.
So, okay,
Don't
so
ask the question
that
if
was.
you don't want the answer.
Do not interrupt me.
Okay.
Answer the question posed by my colleague and then sit down. Answer the question. Go.
The determination if a conflict exists is by its very essence a factual determination.
Sit down.
I was still not.
You answered the question. Thank you.
Thank you.
Your Honors, may it please the Court, my name is Amanda Abata, and I represent the respondents, the City of New York. I wanted to take up here with regards to that Judiciary Law Section 21 argument. I want to note that it really should, I should say as a preliminary matter, that Almadova plaintiff did not raise that issue until about 30 days after the decision and order came out with regards to Judge Kingo's authority to issue the order in the first place. But in any regard, Section 21, like as you will know, it doesn't bar a new judge from resolving a legal question if the judge has reviewed and is familiar with the prior proceeding and no prejudice results from the substitution of judges. Here, the judge, as you aptly stated, decided a motion that only raised the sole legal issue of whether the complaint sufficiently states a cause of action. It was a pre-answer motion. There was no testimonial evidence. The motion was supported solely by the complaint. And the only analysis essentially involved weighing the parties' legal arguments. And as we can see from the decision, the trial court did an extensive discussion with regards to each element and each claim that plaintiff puts forth. So the judge had appropriately reviewed and was familiar with the prior proceedings. And in any regard, I also want to touch briefly on other re-argument bases here with regards to plaintiff's argument that he could amend as of right under CPLR 3025A or 3025B. We see here that neither statute authorizes amending a complaint after the complaint has been dismissed, which is what happened.
In the cases that were put in were a different situation. I mean, the amendment may have been submitted while the motion was pending, but not after the case was dismissed.
Exactly, Your Honor. Like the case he relies on principally is Rome, and that case authorized filing an amended complaint while the motion to dismiss was pending.
Yeah, I
which is
think I sat on that case, and Justice Kennedy, well, I think the three of us sat on Rome.
So you're aware, it's a key distinction. And I just want to go back briefly with regards to the fact that the complaint fails to state a cause of action. This court held recently in Cola versus the City of New York that none of plaintiff's identical allegations here support his claims. In Cola, this court affirmed the Supreme Court's dismissal of the plaintiff's complaints alleging religious discrimination, the failure to accommodate, aiding and abetting breach of contract, violation of the free exercise clause, the declaratory judgment, and attorney's fees. And just as in Cola, the complaint here fails to state a cause of action. Plaintiff's religious discrimination claims fails to connect plaintiff's alleged religious beliefs to the requirement for the vaccination. The complaint offers the bare allegation that plaintiff is a Christian who, pursuant to the tenets of his faith, believed that he was created in God's image. And that simply stated the fact that he's a Christian does not establish a religious belief that is in conflict with the vaccination policy.
You know, counsel, is that even really properly before us? And the reason why I'm posing that is because this is the April 2024 order, right?
Right.
And so when counsel moved to re-argue, really focused on the supposed procedural irregularity and didn't really focus on the merits, right?
Yes, you're absolutely right on
We
that,
don't
Your
need to
Honor.
get to the merits.
Fair enough, Your Honor. So I'll leave that. May I make one more argument
Yes.
with regards to the amendment? I would also posit that that amended complaint fails to add factual allegations that cure the deficiencies. The amended complaint names additional individual defendants. It adds additional claims for intentional infliction of emotional distress, violation of the equal protection, and it alleges disparate treatment and disparate impact. But none of them cure the original deficiency, which include identifying the conflict between the religious belief and the vaccine, the alleged deficiency in the cooperative dialogue process, or the basis for invoking the CBA.
Thank you.
In reference to the amended complaint was never ruled on and never determined by the lower court. The lower court incorrectly, via letter writing, denied me the opportunity to amend the complaint. 3025A is not limited to while a motion's pending. There's nothing in the statute that says that. What it actually does is it extends the time out that a plaintiff can amend a complaint by right without asking for permission, as long as they get it filed within that 10-day period.
I agree with that. That's true. But if the judge had already, or if the court had already completely dismissed your complaint so that there was no case pending, how can you amend a complaint if the complaint has been dismissed? There's nothing left to amend. That's the problem.
Well, because I disagree, because even if reading Rome, it doesn't stand for the proposition that a dismissed complaint doesn't give a plaintiff the opportunity to amend. 3211.
What does?
3211F. 3211F clearly, it's not a one-sided that says only defendants can extend their time to respond. 3211F says both parties. It says everyone has 10 days after the final motion of 3211 to respond to the pleading. I'm just amending the pleading. It's not my client's fault that the lower court made us wait almost over a year. Like, at that point, I honestly had felt that Judge Kim recognized the factual issues and was going to deny their motion. Instead, it's moved from a different judge to a new judge. The dismissal comes in. I say, okay. And the amended complaint, which wasn't ruled on and it wasn't properly dissected, I did have affidavit of NYPD attorney whistleblower Jesse Murphy. I did have the expert report of Charles Baum. And this is all on 3211. This is not a 3212 motion.
Why would you not move to vacate that order dismissing the complaint?
Because I filed the amended complaint, then I re-argued that the judge shouldn't have filed it at all. And then I requested permission to file the amended complaint, which was denied. What else? And it's denied with prejudice by Judge Kingo. It's not even like I can use 205 to now refile. I've been this plaintiff who has done nothing wrong but try to exercise his religious rights has been denied every opportunity of justice by our court system. And the law says it shall be an unlawful discriminatory act by the employer, not the employee. At a 3211 stage, this client should have been entitled to file that amended complaint, and then we can have a proper motion. but a letter writing is not permitted by this court.
Thank you. Thank you both. Gonzalez, v. 60-74, Gansevoort.
Good afternoon, Your Honors, and may it please the Court. Andrew Kay on behalf of Appellants 6074 Gansevoort and NJM Associates. This is what I perceive as a simple case of a misapplication of a statute. The plaintiff was an asbestos abater and stepped into a piece of wood, and his foot went through and is alleging injuries from that accident. The lower court held there was no abatement inspection, engineering inspection, and this was at least a question of fact as to whether defendants violated Industrial Code 23-3.3C, which requires inspections.
I thought, and maybe I'm wrong, that Industrial Code section requires an inspection of demolition work, ongoing demolition work, but does not require a pre-work inspection.
That's correct, and that's exactly our point. The standard that was applied at the Supreme Court level was that we didn't conduct a pre-abatement engineering inspection, and that is why the court held there was a question of fact as to whether there was a violation of
that
this
section.
statute. That's not what is required by this statute. That goes all the way up to the Court of Appeals. It's been affirmed at, of course, this court's level. So once we get past that point, there is no doubt that ongoing inspections were done at this work site on a daily basis. That is rife throughout the record. And so our position is that this particular industrial code was improperly held in this case.
Right, so that's the 241 subsection 6. What about the 200?
Well, for the owner and the general contractor, we were not on site. This is an asbestos abatement. We don't have the right to be on site because everything goes through the abatement company who are licensed and certified. Even plaintiff, who's not here today, at oral argument conceded this is not a means and methods case, that this is a straight whether we were on constructive notice pursuant to 23-3.3C. So assuming there is no argument now of constructive notice.
You have to prove that you had no constructive notice, right?
So by all accounts, the area that plaintiff stepped through was covered by roof tar and asbestos. It took a mechanical saw and a crowbar to expose the wood below this and that is what plaintiff stepped through. There is no way to discover this wood because it's covered by asbestos. So the only people that ever have access to it are the abatement workers.
Well, is that not still an issue or fact? Because didn't plaintiffs testify that he was able to see the second floor through the hole in the roof through which he fell?
Only after he stepped through the plywood and only after they removed the tar and the asbestos in the first instance.
Is that correct? I mean, do we know that? Isn't it still possible that, do we know that it was only after this? Was it not possible that you could also see it prior to the accident?
No, there's no testimony. In fact, the testimony is that you could not see it. The record does contain that evidence.
Well, could you possibly see, maybe there was no hole, but could you see the rotten wood from the second floor?
No, you couldn't see any. So the second floor had a ceiling, and then below, then you're at risk of energizing, whatever the right word is, the asbestos.
Okay.
You can't go through the ceiling to then look below to see what's at the second floor.
But didn't you have some obligation to inspect the structural integrity of the roof and to indicate when you had done that? In terms of constructive
There was an
notice?
inspection of the roof. There was a full asbestos survey. By all accounts, the roof itself looked to be in good condition. The roof consists of the tar and the asbestos. The plywood is below the roof. Plaintiff said each section that they would cut out weighed like 40 to 50 pounds. There's no way to get to this plywood that he stepped through. The hole was only created after he stepped through it.
Counsel,
yeah.
I think we're talking inside out. So you're talking out, and the questions are inside, right?
So
you're saying you're saying from the outside there was no way to determine what lay under the roof, and particularly the roof membrane. The questions have to do with whether an inspection was done from the interior beforehand, to the extent that, for example, a hole or a weakening of the ceiling on the second floor could be ruled out.
It's not the ceiling on the second floor. It is the subfloor of the roof. So in order to access any point in the roof, you would have to cut through the ceiling on the second floor.
You're still missing the question. You're still missing the question. The question is, from the inside, was there any evidence of any failing or any failure or any shortcoming?
There is no argument that there was any, there's no evidence of it. There's no argument that was raised that anybody did anything wrong or improper prior to the abatement itself. There was a complete survey. There were inspections of the building. So,
Thank you. You have time for rebuttal.
Okay, thank you.
Good afternoon, Your Honor. May it please the court, Robert Martin with London Fisher on behalf of Alba Services. There are two simple issues here from our perspective, focusing narrowly. The indemnification provision versus the insurance procurement. Insurance procurement is not before the court, and in fact, there is a separate declaratory judgment action dealing with the insurance procurement, which is active and moving apace. And with regard to the indemnification, Justice Hagler determined that this essentially the decision on it was premature, given the fact that there was no analysis as to the fault of MJM or Gansevoort. So based upon that, otherwise stand on the brief, Your Honor.
Any questions?
Questions?
Thank you.
Thank you, Your Honor.
Just briefly on the indemnity issue, the whole issue is whether there's a question of fact as to whether there's a violation of 200, and then of course the industrial code. Assuming there's no finding on either of those, then the pass-through was clear. There's no negligence trigger in the indemnity agreement. There's no evidence that MJM or 6074 Gansevoort were negligent. I would also point out to the court, we haven't gotten to it. I will rely on the brief, but there is a proximate cause argument that has been raised in the briefs. That is not opposed at any level by the plaintiff, who is, again, not here today to oppose it. So,
thank you.
Thank you, Your Honors.
KSFB Management v. Focus Financial. Yes.
May it please the court, David Cooper from Quinn Emanuel on behalf of the plaintiff appellant, KSFB Management. I'd like to start with the fraud claim, which provides the simplest basis for reversal because defendants do not even attempt to defend Supreme Court's reasoning. What's alleged here is that Goldman Sachs lied that they were committed to a joint transaction when in fact it was a sham to keep KSFB on the hook and get information out of them.
So let me ask you a question, because we tried to read through what we could of the record. After you allegedly had this oral conversation about, okay, there won't be a conflict, we're here in this together or whatever, everything's all good, didn't you then enter into an engagement letter, which you seem to acknowledge that a lot of different things that you might not have acknowledged in that conversation before? I mean, I think that the engagement letter, which came after the oral conversation is the problem. And I wonder if you could address that.
Sure. So two responses to that. First, I think it's important to look at the entirety of that engagement letter. And what that engagement letter says, and this is the language that defendants focus on, is that there may be a potential conflict.
Right.
But they ignore that it also says that the parties will be advised on a collective basis, that neither will be advised independently of the other, and that if there's a conflict, Goldman will require the companies to provide a joint instruction resolving the issue. So very far from sort of conceding that there was this secret alternative transaction, what it reflected was KSFB's understanding that Goldman was continuing to pursue a joint transaction, but there was, of course, the possibility of a conflict at some point in the future. The issue here is not the possibility of some point in the future arising. The issue here was that there was a conflict, and in fact, a conflict that defeated the entire purpose of the agreement right from the very start, and that Goldman lied about it explicitly. And the question as a matter of law is whether or not there can be justifiable reliance. And that question is answered based on whether or not the defendants have peculiar knowledge of the truth. What the Supreme Court said is there has to be a special relationship to invoke the peculiar knowledge exception. That's wrong as a matter of law. Defendants don't even try to defend it. So what defendants say instead is that, well, if the disclaimers are sufficiently specific, then it doesn't matter, the peculiar knowledge exception does not apply. But that is directly in conflict with this court's holding in Basis Yield, which said, quote, even if the disclaimers and disclosures were to be viewed as sufficiently specific, a plaintiff may not be precluded from claiming reliance on misrepresentations of facts peculiarly within the defendant's
So that's what I was going to ask you. So how are all these facts uniquely or peculiarly in the defendant's possession so that you could not have asked questions or done some investigation to have learned this during that time?
So what the complaint alleges is that this entire scheme was intentionally hidden from KSFB. That in fact, for months, Goldman and Focus had been negotiating with CDNR. But to close the deal, what they needed was two things. One, KSFB not to pursue its own deal, and two, information from KSFB.
The NDA, so.
Right. And so the entire scheme, the entire purpose and idea of the scheme was to hide it from KSFB. And that's what's alleged in the complaint. And if there's a factual question regarding whether or not, in fact, this was peculiarly within defendant's knowledge, that's not a question that can be resolved on a motion to dismiss. The complaint alleges, I point this court's attention to paragraphs 164 to 66 of the complaint, specifically that not only did KSFB not know, that they could not have known. There was no way to know, both because Goldman hid it from them and then lied to them.
So once you sign this this written engagement letter that says there could be conflicts, which you thought there weren't going to be conflicts, now there were, shouldn't you have done something else? Shouldn't you have asked more questions or asked for more information to learn what was going on? Didn't this put you at least on some kind of inquiry notice that something was going on that you might not have anticipated before?
So two things. One, they did ask, and that was actually the impetus for Goldman lying to them, which is that they did say to Goldman, isn't there potentially going to be a conflict? And Goldman said, no, don't worry about it. We're going to pursue the joint transaction. So they did ask about it. The second thing is that no one who hires a banker, remember, this was a joint hiring of Goldman. Focus didn't just hire Goldman. Focus and my client, KSFB, jointly hired Goldman. No one who's hiring Goldman Sachs thinks that Goldman Sachs is going behind their back to perform a transaction that's already started and that they haven't told you about only for the other party to that joint hiring.
Even if there are red flags, you still are not going to pursue any type of investigation?
So I don't think there are any red flags here, and certainly nothing within the complaint suggests that there are red flags. But even if there were, that wouldn't defeat—
Counsel,
I'm sorry, excuse me, let's finish the answer. I'm sorry.
Oh,
then
I'm
you
sorry.
Can answer. I'm sorry.
I was just going to say, even if there were, that wouldn't defeat fraud. That's not a defense to fraud. There would be a question about reliance potentially, but that would be a factual question not to be decided on the pleadings.
Yes, Justice Gonzalez.
Thank you. I have to say that it's a little unusual to have anyone representing both sides as opposed to everybody having independent bankers, representatives, what have you. The part that bothers me, and I will say it candidly, is that on the one hand, the engagement letter says no company will be advised independently of the other, and Goldman Sachs will not negotiate for one company against the other with respect to any issue that may arise in connection with the transaction. But then it goes on, and that's where my colleagues are asking about the red flags. Each company understands and acknowledges that potential conflicts of interest may arise, and then it says, and here for me is like the biggest flag. Furthermore, each company understands and agrees that Goldman Sachs may currently be providing, and may in the future provide financial advisory and so on that that could impact the transaction contemplated by this letter. Do you have anything in writing by Goldman that says we are not currently involved in any type of transaction that's going to hurt you, or something that says this is what we're doing? I mean, what did you do? What inquiry and what responses were made?
Sure. So I think, I don't know of anything in writing, so that's the short answer to the question. I think the more important answer, hopefully, is that something that may impact the transaction is not what actually was occurring there. And it's important to keep in mind, the engagement letter was signed literal days before they closed the other transaction. So even if there was a red flag, there wouldn't have been time to discover the transaction that was literally on the verge of closing. But the other thing is, if we look at the actual language, when it says they won't be advising just them, that if there's any conflict, we're going to go to you. When you look at it in that context, the idea that there may be some impact says nothing about the fact that that impact would come from the fact that you were advising Focus completely independently. And that, in fact, not only could you do that, you've already been doing it for months to perform a transaction that made the actual transaction you were hired to do completely impossible.
Counsel, I'd like to move to another area because you also, claim that there was a breach because the failure to provide access to the CD&R data room. So my question is, where in paragraph 8 does it state that Goldman was required to, set up a separate data room or platform to share Focus's confidential information with CD&R?
Sure. So what paragraph 8 says is that, and let me bring up the language specifically. Any confidential information received by a disclosing party includes Focus and KSFB, will be available to the other disclosing party upon request. So any data room is including information from a disclosing party, here generally Focus and KSFB. It specifically alleged that KSFB asked for access to any data room and to any information that Goldman was providing to third parties. And Goldman not only didn't provide the information in the data room, they didn't even tell them the data room existed.
Because, and the reason why I oppose that, because they weren't seeking to purchase, plaintiff. They only needed Focus's, information. So that's why I'm posing that question to you.
Sure. So the complaint alleges that the data room for CD&R and the information given to them included both information from Focus and KSFB. But honestly, it doesn't even matter because the definition of confidential information, and this is at the very beginning, says any information from KSFB or from Focus. It uses the term disclosing party, which includes both.
Thank you.
Thank you, Your Honor.
Good afternoon, Robert Triffill with Sullivan Cromwell for Goldman Sachs and Patrick Fells. I think there's a little bit of confusion here about what's going on. In 2018, a company called NSKFB sold itself to KSFB, which is owned by Focus. And that was a transaction where they gave over all the assets, all the information, and essentially entered into a management contract with the buyer. And when that was done, they agreed that they wouldn't be able to even sell themselves without the consent of the buyer because they made millions of dollars. So what happened? That firm was then acquired by Focus, which is a huge financial conglomerate that had 90 separate businesses. It entered into a transaction subsequently with Clayton Dubilier and Rice and did a go-private transaction. It was a public company, and that transaction went forward. Now, what they're complaining about is quite remarkable because after the big transaction was completed, Goldman Sachs presented these folks with 5 bids and they walked away. They didn't pursue it. In fact, Clayton Dubilier and Rice was more than happy to sell KSFB, and they walked away. So let's talk about, that's what's going on. They don't have any rights.
So counsel, let's talk about the engagement letter once again. This is a really unusual agreement or statement. It says we're not gonna advise you independently. We're gonna, but we might be helping the other guy to do something that's gonna tank transaction. And we may be doing it right now as this document is being written. Your friend here says basically that you rooked his clients, that you were, not you, I'm sorry, but your clients, your clients were scamming them. So what happened here?
Completely not true. First of all, there never was a conflict. Number 2, which is why there was never a need to even have a discussion about it. Number 2, they were a sophisticated party represented by counsel. The actual engagement letter.
Yeah, but you've seen a lot of sophisticated parties get into trouble, right?
But Your Honor had it exactly right. The engagement letter says, number 1, we're going to be providing services to both of you simultaneously. Our interests may not always be aligned. And it goes on to say specifically, each company agrees that Goldman may be providing services that could impact to another company that could impact the transaction contemplated by the letter, and Goldman may learn information that will not be able to disclose to the other party. There's no allegation in the complaint that anyone from plaintiff ever asked Goldman Sachs, what was the other transaction? What was it doing? No, there's no claim, and he conceded that there's nothing in the complaint about that. So this is standard language that they worked out specifically to deal with this situation. Again, I go back to what I said at the beginning. This is a small company at the bottom of a much bigger pyramid, and they're essentially saying that Goldman Sachs somehow did something wrong when it was dealing with a bigger transaction. Goldman Sachs went forward and actually was prepared to do a deal and had 5 bids identified, and the plaintiff walked away because he was looking to get a windfall he was not entitled to. He'd already done a deal where they sold the business to Focus in 2018. They sold all the assets, and there was no issue of doing anything wrong and in fact, this court's decisions, and we would cite the court to Silver Lake in particular, clearly say that when you disclose to a party that you may be providing services to another party and it may impact this transaction, that you've done full disclosure, and that obviously trumps whatever oral statement would have been made.
Can I ask you something, Mr. Giffra? So this engagement letter was entered into sort of at the end of this process, as plaintiff said, shortly after the deal was done. Would they have had time to, once they entered into this engagement letter, to have asked you or found out information? Was that possible?
Certainly, and in fact, Your Honor, after the Clayton Dubilier, the bigger transaction was done with the public company, Goldman Sachs presented them with 5 bidders to buy both businesses, and Clayton Dubilier, the buyer of the entire business, was happy to sell the NKSB business, and they walked away from it. So the transaction was going forward. Goldman obviously wanted to make a fee and was prepared to go forward and do a deal, and they walked away. They had an engagement letter. They're a sophisticated party. They'd been working with Goldman Sachs for several months before that. The engagement letter had been negotiated by sophisticated parties to figure it out, and the engagement letter on its face says that Goldman Sachs may currently be providing investment banking services that, quote, could impact the transactions contemplated by this letter. And surely that's correct. No one's disputing that. And there's no allegation that Goldman Sachs lied to plaintiff and didn't tell them about. There's no allegation we asked and we're not told. And so under settled New York law, they are bound by the engagement letter that they signed, knowingly did. So I think that Justice Chan had it exactly right. And in fact, this notion.
So counsel, Justice O'Neill-Levy has a question.
No, I just wanted clarity. So plaintiff was on notice of all of these transactions. Plaintiff was on notice, they had the engagement letter, there wasn't anything that was contradictory.
Plaintiff signed an engagement letter that said on its face that the interests may diverge, there may be conflicts, And in fact, the purpose of the engagement letter, as stated in the engagement letter, was for a sale of either NKSFB, which is the main company that had all the assets, or the service company that was set up by plaintiff. And the sale could have been for one or the other, or neither. And that was all disclosed in the engagement letter. Then the engagement letter made clear that Goldman might be providing investment banking services to other parties that could impact the proposed transaction. That was true too. There's no allegation that plaintiff ever asked Goldman Sachs, what are these other transactions you may be working on? We told them there may be other transactions, and they never asked about it. They were on inquiry notices, the court properly noted, and they never asked us a single question. Then after the bigger transaction that they complained somehow had an adverse effect on the transaction they were looking to do, and this is in the record, and this was, I think, persuasive to Justice Chan, was they walked away after Goldman Sachs said, notwithstanding the bigger transaction, we have 5 bidders to do this small deal, and they didn't want to do it.
So this was after the big one closed,
Yes,
this happened?
Yes, exactly.
Thank you, counsel.
Okay, and then if do you have any other questions on the confidentiality issue?
No, your time is up, though. Thank you.
Briefly, just a few quick points. First, the question is whether there was peculiar knowledge of the truth, and what the truth is, according to the complaint, was that Goldman Sachs was not pursuing a joint transaction at all, that the entire thing was a sham. There was no inquiry notice, no notice of any kind that Goldman Sachs was not pursuing the transaction that they were hired.
But the thing is, they say, I mean, even though they may not use that language, in this engagement letter, that they're advising both sides, that there may be conflicts. I mean, but gosh, if you enter into something like that, an agreement like that, kind of give it, it's almost like you're giving away the story. Yeah, okay, you can do this, well, we can do this. There could be conflicts, and I don't know.
But there's a difference between a conflict and not actually pursuing the joint transaction at all. That's not a question of just a conflict.
So you're saying they never were at all, or by this time they had stopped?
No, at all. The complaint specifically alleges that the entire supposed attempt to sell it on a joint basis was a sham.
But I thought your friend stated that they actually brought to you certain sales, which you turned down.
No, so that's basically their testimony. That's not what the complaint says. What the complaint says is, in fact, that yes, they went out to bidders and claimed that's what they were doing, but the entire goal, the purpose of it, was simply to undercut KSFB, sell the whole thing, and then make a deal that would be at all reasonable for KSFB completely impossible. So this idea that once they actually sold NKSFB, that then KSFB should enter into a transaction was ludicrous. It made no sense because at that point, KSFB had no leverage to do anything. And again, these are all factual questions that should be decided at summary judgment or trial. The question is whether or not Goldman Sachs was actually engaging in what they were hired to do or was entirely a sham. That's a factual question. The complaint clearly alleges that it was.
Thank you. Last case for argument is People v. Omar Key. Whenever you're ready.
May it please the court. My name is Ian Hayes, and I'm a Cornell law student representing Mr. Omar Key under the supervision of the Center for Appellate Litigation. Because the police never recovered a knife in this case, the ostensible murder weapon, the key question was how the jury would interpret the surveillance footage. But they never had the opportunity to because Detective Smith told them what to think.
Well, did they view whatever surveillance video was available?
Yes, Your Honor, but at the same time, Detective Smith was narrating the surveillance footage. This case was entirely circumstantial. The surveillance footage was the most important evidence, in fact, the only evidence in the case. And contrary to the test that the court laid out in Mosley, Detective Smith testified to his opinion about this particular.
He testified to, he said that he stated what was being seen in terms of the defendant having a knife or having something in his hand, the deceased being stabbed. But wasn't that in reference to or response to the defense's position that this was somehow a rush to judgment?
No, Your Honor. The court was allowing him to testify as to what the investigative steps that were being taken.
Right, because there was some indication or some argument that it was a rush to judgment because it should have been Bronx Deuce or Deuce, whatever, who was the actual perpetrator and not the defendant, right?
Your Honor, but under the standard in Mosley, Detective Smith could, testify to what these investigative steps were, but not directly to what is in the video. It's helpful to look at the particular statements that he made. He says, if you go back a little bit, the individual has a knife in his hand. No one else had a knife in his hand. He approaches the video after asking permission and says, as the fight ensued, you see Mr. Omar Key, very agitated, walking towards the victim, as if, look at his feet. Even though shades are down, look through these cracks, you see he chased after our victim.
So the jury is viewing the video as well, right?
Correct, Your Honor.
And so did the judge also give an instruction or curative instruction to the jury that regardless of what the detective said, that the jury would make the final determination as to what was depicted in the video?
Yes, Your Honor. There was a curative instruction, but this court and the Court of Appeals routinely recognize that curative instructions are not a cure-all here. Here, this testimony was very prejudicial. And the state doesn't even argue that this was not prejudicial because they cannot. Here, Detective Smith, who is a 20-year veteran of the NYPD, the lead detective in this case, is saying, this is a knife. Only the defendant has a knife. There is no way for this bell to be unrung.
Now, this argument about Detective Smith providing a narrative, was that argument made below?
Your Honor, not in these exact words, but
So what was the argument below?
the argument below, Your Honor, was that he was testifying as to if there was a knife, and that it was there was a sidebar to this effect, and then it was brought back onto the record. Now, if I may briefly talk about the weight of the evidence. Even if we are to assume that what is depicted in the video is a knife, and there's clear reason, many reasons to believe that it's not, the state is unable to exclude all reasonable hypotheses of innocence, as it's required to do by People v. Vaque. One of these reasonable hypotheses of innocence is that another participant was the one that stabbed Mr. Duchenne. Now, if you look at the videos closely, Your Honors, and I encourage you to look at these videos, there are multiple other participants that have reflective items in their hands. The state doesn't explain how these are definitively cell phones, but in Mr. Key's hand, that this is definitively a knife.
Is it definitive or beyond a reasonable doubt?
Beyond a reasonable doubt, Your Honor. But even so, the standard in Baki is that is meant exactly for cases like this. This case is a black box. We have nearly 6 people involved in a chaotic street fight. Most of it is obscured either by camera angles or buses or cars that pass by. And to prevent the jury from making logical leaps, the state must exclude all reasonable inferences of guilt.
So, back to the video, I'm sorry.
Innocence.
So in the video, there is, the people's argument is that the defendant had a knife, right? And that he stabbed the deceased. The deceased had a backpack, I think. And so after, the defendant goes into this crowd or whatever with this object, which the people say was a knife, and then he comes out of the crowd with the backpack or whatever, the fanny pack or whatever, that the deceased apparently had. I think also the defendant identified himself as that individual in the video as well, right?
Yes, that's correct, Your Honor.
And maybe I'm confusing cases. Did the defendant have blood on him, or was there some blood on the defendant when he comes out of this crowd?
No, Your Honor, that is not correct. Detective Smith made a conclusion that in the video, the defendant was looking down to check his shirt if there was blood, but there was no blood on the defendant.
Oh, but there was a trail of blood, right? And there was a trail of blood leading across the crosswalk, and bloodied clothing was found with holes in it on the crosswalk, which apparently belonged to the deceased.
Detective Smith says that blood can be seen in the video,
Right.
But the prosecution did not even try to test the blood that was found at the scene. They did not try to test the blood or the DNA that was from these different objects. Even if the defendant, took this backpack that did not belong to him, and this can be seen in the video, this does not establish that he was the one who stabbed the deceased, Your Honor.
Thank you. You have time on rebuttal.
Thank you.
Good afternoon, Jonathan Gold for the People. There's no argument that this is a circumstantial case. However,
So we have all these other individuals who are involved. How do we get to the defendant as the individual who was the person who stabbed the deceased, I think, twice in the heart?
it's unclear whether it was once or twice, but
Once or twice in the heart.
we get there from the fact that he is quite clear. The video evidence speaks for itself. Although,
Well, if it speaks for itself, then, I wonder why we had a detective narrating it for the jury.
we have a detective providing, testimony about what he thinks he sees in the video for the limited purpose of explaining why the investigation proceeded as it did, and to counteract the defense's theory that was advanced, from the outset.
That they
that
should
there was
have arrested Deuce or whoever was the individual who the sister says she was told committed the homicide from some individual who knocked on her door that evening.
Yes, the rush to judgment theory. The people have to be allowed to explain why the investigation went the way it did. And again, the video, which I believe we provided, is quite clear. The defendant is there. It's holding what is clearly a knife.
Can you really tell that it's
clearly?
Yeah.
I'm sorry.
Can you really tell that it's a knife?
He's holding it in such a way that it protrudes from his hand. He pulls it out of his pocket sort of like this. He moves it at one point in sort of a wide arc, out of the way of another participant in the fight. I submit that suggests he understands that this is a dangerous item he's got.
So I know that the judge gave a limiting instruction saying that you are the triers of fact and it's up to you to decide what you see. But isn't the prejudice of having as counsel indicated, of having an experienced detective sort of telling them what he sees in the video, doesn't the prejudice of that somehow outweigh the probative value?
I wouldn't agree. I think that, first of all, it's presumed that
Juries
limiting
listen to what the
instructions.
judges say. Maybe.
Yeah, People versus Morris, People versus Baker, et cetera. I also think that it's not just one curative instruction that was given, it was several. There were curative instructions given immediately after that testimony. There were curative instructions given during there were, the trial ADA, closed by exhorting the jury to watch the video, make your own decisions, and I submit that is exactly what they did. I wanted to address as well weight and sufficiency. I think that the defense, talks about Baquet, which that case does note, however, that circumstantial evidence does not impose a greater burden of proof than the traditional beyond a reasonable doubt. It just draws attention to the fact that the facts have to be rigorously observed there.
He was convicted of the manslaughter in the first degree. He was acquitted on the murder, and he's sentenced to what was he sentenced to?
15 years, I believe.
15 years. So it's just under the max. That is the max on the man one, right? Or 25? Anyhow. The defense is asking for a reduction in the sentence.
I would simply say that the defendant has 13 convictions on his record, 2 prior violent felony offenses. He has yet to be dissuaded by the comparatively lenient sentences he's received in the past. And couch it how you like, I believe the evidence quite clearly shows that this was a brutal and senseless crime. The defendant approaches a brawl in progress. He has no reason, he has no apparent need to get involved. He pulls out a knife, he stabs Marvin Duchesne to death, and before walking away with his bag. It is a brutal and senseless crime, and I do not believe that the sentence was excessive.
Thank you.
Thank you, Your Honors.
Two brief points on rebuttal, Your Honor. Bakke requires that the state prove beyond a reasonable doubt, exclude all reasonable inferences of guilt, all reasonable inferences. And there are many reasonable inferences of innocence. And all reasonable inferences of innocence remain from this video. The state also tries to have it both ways here. They try to say that the knife is clear from these videos, but if it's clear from the videos, then we don't need the narration of Detective Smith. But if perhaps this is ambiguous, then Detective Smith's narration is completely invading the province of the jury. The court in Mosley was concerned with independence. They were concerned with the jury being able to independently come to a conclusion about what the evidence says. And here, they are unable to do that because an experienced detective is telling them definitively, this is a knife. Not, I believe this was a knife, or I came to think that this was a knife, but that this was a knife, that no one else had a knife. This is the prosecution's entire theory of the case. The entire theory of the case is that Mr. Omar Key is the only person who has a knife and that no one else does. The judge essentially allowed the prosecution's witness to have his lay opinion masquerade as objective and expert fact. This is far beyond what even the judge said that he was allowing. This goes far beyond this rush to judgment, but is allowing Detective Smith to definitively say to the jury that this is what you see and this is how you should think.
You're at Cornell?
Yes, Your Honor.
What year are you in?
I'm in my 3rd year.
Excellent. You did an excellent job. And good luck to you in your future defense endeavors.
Thank you very much.